A very good morning to one and all present here today. I extend my warm welcome to all of you for the third session of the 14th National Webinar Series. The famous American writer Mark Twain has said that he has praised our motherland, and while praising him, he has said that India is the cradle of human race, the birthplace of human speech, the mother of history, the grandmother of legend, and the great grandmother of tradition. Our most valuable and most instructive material in the history of man are treasured up in India and India only. So as to unearth these treasures and understand the beauty of our legal philosophies, we at Kelly College of Law, Navi Mumbai have organized this webinar series on the theme of Bharatiya legal philosophy and inclusive perspective. And it gives me immense pleasure today to welcome our guest speaker, Professor Vikramaditya Rathore from Savitribai Phule Pune University, who is going to deliberate on the topic of Bharatprudence, the Groundnorm of all legal philosophy. Thank you so much, sir, for accepting our invitation. I would now like to request Principal Sir to welcome our guest speaker.
Thank you, Madam. On behalf of KLE Societies, KLE College of Law, I welcome our guest for today, that is Professor Vikramaditya. Thank you, sir, for sparing your valuable time, for sharing your knowledge with KLE students, and you have agreed our request. And thank you so much, ma'am. Over to you. Please kindly go ahead.
Thank you, sir. I would now like to request Professor Ruchira Halli to welcome and introduce our guest speaker.
Thank you so much, Sushmita ma'am. A very good morning to one and all. I am Professor Ruchira Halli, and it gives me an immense pleasure to introduce our guest speaker for today's session, Professor Vikramaditya Rathore. Sir is working as an assistant professor at Department of Law, Savitribai Phule Pune University. Sir has 3 years of teaching experience at postgraduate and undergraduate level. Sir has qualified UGC NET JRF in December 2016 and is currently pursuing his PhD titled as Interstate River Water Dispute in India, Impact on Federalism at Department of Law, SPPU Pune. At the Department of Law, Sir has coordinated the online entrance test for LLM, student induction and orientation program Diksharam. Sir has coordinated the national seminar and national workshop in collaboration of Indian Society of International Law, New Delhi, and Department of Law, SPPU. Sir has also worked as a visiting faculty at BA Liberal Arts Interdisciplinary School of Science, SPPU, and New Law College, Bharati Vidyapeeth, Deemed University, Pune. Sir has represented India and participated in 3rd BRICS Student Spring Festival, Stavropol, Russia, in the year June 2019, organized by the government of Stavropol and Russian Union of Youth Russia. Sir has guided the project by Pune Zilla Parishad, Government of Maharashtra, titled as a study of court cases in respect of inter-district and inter-district online transfer of Zilla Parishad teachers. Sir has also associated with research for Resurgent Foundation Nagpur, wherein he has coordinated as a research workshop at the Maharaja Sayajirao University of Baroda, Gujarat, and Dr. Ram Manohar Lohia University, Ayodhya. Before joining the academics, Sir has practiced as an advocate in the jurisdiction of Rajasthan High Court, wherein Sir was engaged in drafting and pleading of issues related to writs and criminal matters. Jurisprudence, constitution and constitutionalism, administrative law, criminal law, religion and spirituality, Hindi poetry and literature are Sir's area of study and interest. Thank you so much, Sir, for accepting our invitation. We look forward to hear from you on this interesting topic. The session is over to you, sir.
Thank you very much, Professor Ruchira. Am I audible?
Yes, sir, you're audible.
Okay, thank you. First of all, I extended my thankful regards to KLE College Principal, sir, and all other staff who has given me opportunity to bring before you an important subset of a very important theme, which is actually chosen by the KLE College for this seminar, for this webinar. First of all, I must say that it is the need of the day. The theme which chosen by this college is it is a need of the day. Why that particular theme is a need of the day, that we have to understand. Dear students, on 15th of August 1947, we have got the one aspect of our independence, that is a political independence. The independence itself has a two aspects. The first one is a political independence and the second one is a social independence. On 15th of August 1947, we have achieved the first one, that is a political independence, but still we are in the process of achieving the social independence. And dear students, the social independence lies in the fact that how free is your society. Free in the sense that whether your society has all those enriched value which are their original values. Do they have? Now question come before us that since 15th of August 1947 to till now, do we have our own social values? And my dear students, social values will lead us to frame the legal values which ultimately lead to frame the legal system. So if you have your own legal system, it reflects that yes, you have your own social values as well, and it will ultimately reflect that yes, you will get or you are getting the social independence. So India's social independence will lie into the fact that do we have our own legal system or not? Do we have our own original legal system or not? And clearly, when Kelly has drafted the theme of this particular webinar, they actually come out with this proposition that now the time has come to think over it, to rethink over it, that do we have our own legal system? And whether our legal system, if we have our legal system, that whether our legal system has the Bharatiya essence or not. If we have a Bharatiya essence in our legal system, we can say that yes, we are on the way to achieve the social independence. And today, with my topic that Bharatprudence, which is the base of all legal theory, is an attempt to dwell out this particular thing. That, and I'm totally agree with this fact that yes, we have our own legal system, and our legal system, which is generally it says that our legal system has borrowed from the foreign land, or we are generally go through with the Western philosopher to understand our legal system. But this is not the true fact. The fact is that whatever the principle lies in our legal system, or whatever the legal philosophies which we learn in our legal classes, in our law classes, are basically, we can trace out all those principles and the philosophy in the ancient past of our land, that is a Bharat. That's why I have mentioned this term Bharatprudence. I just want to start this theme of my lecture with one example. You all are aware with the principle of equity. And it is said that this particular principle is originated from the common law principles from the courts of the UK, Britain. And accordingly, we have also opted particular principles. And now we are usually use that particular principles in our court system, in our legal system. And it is said that it has inherited from the from the UK's code. But when I gone through with one of the literature of the ancient past, Rathore, it is basically an history of an Kashmir. One of the philosopher, writer, Kalhan, he has written that particular document, particular book, Rathore. There is one incident in that particular book. It was like a story. In that particular story, it is said that one of the trader who has earned 100 coins with his hard work, with his effort, one day with these 100 coins, he was going through with from a particular route, and unfortunately, he has lost all his money. So all monies were lost into a well, and he was very unhappy with that. He was at that time, one person has come to him and he has said that if I will bring out your all money from that particular well, would you give me whatever I want? So that trader has told to him, okay, I will do that. That was an offer from the side of the that person, and the trader has accepted. In legal parlance, if we see, that is a contract, that is an agreement. So accordingly, that person went into the well and he brought out those all 100 coins. And the moment he has handed over those money to those all coins to that traders, he has told to him that now, in accordance with the agreement, I want 96 coins out of the 100 coins for this particular venture. I have bring out all those money. So that trader got shocked. He was not expected that. He was expecting that most of, it might be possible that he might ask for 1 coin or 2 coin, but now he's asking about 96 coins. What about my hard work? What about my efforts? And a contest and a dispute arose, and both of them gone to the king. And when king has heard all the matters, the king has said that if we go through with the laws, written laws, it is in contract. And in accordance with the contract, the trader is bound to pay whatever the requirement of that other person. But it will go against the justice. It will not the just act. So it is quoted in that particular story. So equity demands, samatva require kar raha hai. Equity demands that 96 coin will be hand over to that traders only, and the 4 coins will be hand over to that person. The good concise, and in the name of the equity, those 96 gold coins will given back to the original owner of those all coins. Now, if we compare the story, the principle which is inherited in which is inscribed in that story, that is the principle of equity. Rathore was written at around 11th AD. Common law principle and common courts had developed this concept in 16th or the 17th AD in a UK. So 600 years back, the India was following the principle of equity. We were following the principle of equity. It does mean that whatever is in our legal system has their roots in the past of India. And I'm saying each and every principle which you find in our legal system, if you analyze those all principle. And if you compare with the old or with the ancient legal system of India, you can in a stage wherein you can say that yes, those all principles which are prevalent today has their roots, has their back in the past of India, in the ancient legal system. The knowledge of the Bharat, that is a prudence of the Bharat, that is a Bharatprudence, can be seen in a contemporary legal system. And when I say that each and every legal system, it does mean that the knowledge of the Bharat, that is the prudence of the Bharat, was so rich. And why it was so rich? If you gone through with the each and every principle which are prevalent today in Indian legal system, you can trace out those all principle in an ancient legal system. It does mean that ancient legal system has an inclusive approach. Ancient Indian Bharat system has an inclusive approach. And what is the reason behind that inclusiveness? The reason is that the Indians, that the Bharatiya had an seeking nature. They were not a believers. You know what is the meaning of Bharat? The Bharat, the meaning of Bharat, the Bharat actually, the etymology of Bharat, if you see the etymology of the Bharat, this particular Sanskrit word made up of the two words, Bha plus Rath. Bha means the light, the radiations, the radiant, the ultimate truth. And Rath means engrossed. Engrossed means lage rehna. यानी वो जगह जहां के लोग लगातार सत्य और प्रकाश की खोज में लगे रहते हैं. The place where peoples are in the habit of seeking the ultimate truth and the light. They never believe. They never stuck on that particular issues. वो किसी एक particular issue पे stuck नहीं रहते. They have a tendency of the seeking. Just because of this seeking nature, the Hinduism developed the Buddhism developed into the Jainism. This is the seeking. We never stuck on any particular idea or the philosophy. हमको लगा कि नहीं, Hinduism से भी थोड़ा कुछ अलग चाहिए. We have developed the Buddhism, and then we have developed the Jainism, and then again we came back to the Neo Hinduism. That is why, because we have a seeking nature. Bharat, Bha plus Rath. First, the people, the place where people are involved in the seeking the ultimate truth. So just because of this Bharat, the name of just because of this nature of the seeking, we have developed so many principles. We have developed so many legal theories in our past that today, if you go on through with the today's legal system, legal principles, you can find all those principles in ancient past of the India. I will give you some examples. You all are aware with the idea of secularism. If you've gone through with the Indian Constitution, one of the basic fundamental right which reflects the idea of secularism is Article 25. Article 25. Article 25 of the Indian Constitution says that each and every Indians or each and every person has a right as a freedom of concise and a freedom of propagate their religions or to profess their religion. There are the two parts in that particular article. The second part is that each and every person can profess, then propagate their religions with some subjective, with some restrictions, reasonable restrictions. And the first part is that each and every person has a freedom of concise. Now it is important. Secularism means that state will not interfere into your religious matter. That is the basic idea. The state and religions will keep apart. In a secular country, in a secular principle. Now, if you compare this concept, and what is actually freedom of concise? Freedom of concise means that particular article says that If you want to propagate, if you want to profess your religion, you are free. Whatever religion you want to profess, whatever religion you want to propagate, you are free. But suppose if you don't want to opt any religion, if you want to remain atheist, if you understand this thing, that now I am on that stage where I don't need help of any religion, even at that point of time, you are free to opt that particular idea. That is a freedom of conscience. If you want to remain atheist, if you want to remain agnostic, if you want to remain non-religious, and if you have already felt that now I am on that particular stage wherein I don't need any type of religion, my conscience is my best friend. I can understand the whole world without religion. I can understand the invisible things without religion. You can do that. Article 25, the first part, freedom of conscience, allows you. And that is a very rare thing. It is not an ordinary thing wherein you can say that, yes, now my conscience is so developed that I don't need freedom of profess, religion and all this thing. Now I will do all the thing with my idea, with the help of my conscience. That is a freedom of conscience. It is also given as a fundamental right. And now if you went back to the past of the India, there is one philosophy, one Vedantic philosophy, that is Advaita. Advait. What Advait says? Advait says that there is nothing like a dual. There is a oneness everywhere. Advait says that when you follow some duties, when you follow some practices, after some time you will reach to the stage wherein you can say that now I don't need any religions, any practice, any spiritual leaders, any spiritual guru. I am the guru of myself. Now my conscience is itself is so enriched, is so powerful, that can guide me, that can help me to get the ultimate truth of the life, to get all type of freedoms. Now I am boundless. That is Advait. Non-dual means there is nothing like any other personality. कोई कुछ और दूसरा है ही नहीं. अब तक मैं ये समझ रहा था कि कोई दूसरा भी है, तीसरा भी. No, nothing is like that. There is only oneness. We all are equal. We all are one. So Advaitas describe us the first thing, that all are equal. Right to equality, Article 40. And Advaita tell us that your conscience is important. So work on your conscience. So work on the oneness. That is a freedom of conscience, Article 25. Secularism. So Article 25, Article 14 can be related back to the theory of Advaita. Advaita is the philosophy which tells us that when you reach to the higher level of your identity, when you totally groom your personality, at that point of time, you will not attach with any type of other identities. Like you will forget what is your caste, what is your religion, what is your relationship with other family members. At that point of time, you will feel that you are an powerful individual. That is Advaita philosophy. That is the same thing, which actually the idea of the fundamental rights are there to understand us. They give us message that you are an individual personality. You have to understand, you have to understand this fact that you are an individual personality and you will have to achieve the fuller personality. That is what Advaita tells us. Advaita tells us that if you will follow some practices like pratyahar, pranayam, yoga, you will reach to the stage wherein you will feel that now I am a complete individual and complete individual. And whatever is around, whatever is there in vicinity of mind, all are me. We are not different from others. At that point of time, you will forget your all other identities, like whether you come from that religion, you come from that caste, you come from whether you are rich, whether you are strong or poor or weak, whatever the identities, all identities will go into the when you reach the higher stage of Advaita. And it is very important in a legal perspective. In your upcoming class, when you will study about the John Rawls, John Rawls has said that for a just society, it is necessary that we need some just principle, fair principle. And fair principles will be made only when you have a persons, when you have a policymakers who are fair, whose ideas are fair. If your policymakers have the fair tendencies, if your policymakers follows the justness, reasonableness, fairness, if your policymakers are not attached with any type of biasness of religion, biasness of gender, biasness of the sex, biasness of the money, biasness of the strongness, weakness, if they are not attached with all such type of biasness, they will be able to make the fair principle for the just distributions of the resources. That is what John Rawls has said. So for fairness, for the distributions of for the fair distributions of resources, the person must be an unbiased. He must not have attached with any identity. He must not have a position to favor any type of person. He must be a spiritually clean. So only in that condition he will make good principle or fair principle. And on the base of these assumptions, John Rawls has given some principles like principle of equality, principle of liberty, and principles of the differences. But when he has given his theory, he himself knows that it is impossible. It is impossible to pick out those policymakers who are absolutely unbiased. So he has assumed all this thing and he has given an idea of hypothesis equality or hypothesis unbiasedness idea. So he has hypothetically considered all this point and on the base, he has given some principles. But when you trace back to the philosophy of Advaita philosophy, which has said that there are some practices, there are some procedures, there are some methodology. With the help of those practices, with the help of those methodologies, a person can reach to that stage where he will not attach with any type of other identities or biasness. Practically, it is written in the Vedantic philosophy that if you follow the pratyahar, if you follow the yogas, if you follow some other practices, you will certainly reach to the stage wherein we can say that, yes, now this person is totally unbiased person. And when he will make the policies, the resources will be distributed in an equal manner. What John Rawls has failed, Vedanta philosophy has already explicated 1,000 years back. But we are failed to compare it with the Vedantic philosophy. That is the problem. I want to take one more example, which is also very important. When we see that apart from the Vedantic philosophy, there is one more philosopher which we generally read in our legal perspective, that is Immanuel Kant. He is one of the best philosophers in the world. First, we will try to understand what is actually the idea of the Immanuel Kant. Immanuel Kant has emphasized on the means rather than on the ends. According to the Immanuel Kant, we must not see the end. We must focus on the means. If our means are pure, the end will itself become a good or pure. The justice will be done if your means are. We will try to understand the Kantian philosophy in comparison with the Bentham. I just want to, and Bentham has emphasized on the ends, irrespective of any means. We will have to focus on the end. That is the Bentham idea. But the Kant idea, the Immanuel Kant idea is that we have to focus on the means rather than ends. We will try to distinguish both this idea with one example. Suppose you have a jeep with you, and on a very bent slope you are driving your jeep, and unfortunately suppose if your the brake of the jeep has got failed, and what you will see that at the end of that particular road there are two diversions. On one diversion there are two peoples, on the other diversion there are the 5 people. What will you do? Most probably what we will do, we will try to take our jeep to that place wherein 2 people are there, because what is in our mind, that it is better to save the life of 5 people rather than a 2 people. 2 मरते तो चलेगा, लेकिन कम से कम 5 लोग तो बच रहे. It means you are applying the Bentham's theory. You are not seeing to the means. Whatever is important for you, the end, whatever the end is, end देख रहे हो आप. 5 लोग बच रहे, 2 मर रहे, चलेगा. You are seeing the end. Utilitarian principle, the maximum happiness to the maximum people. If 5 peoples, if the life of the 5 peoples is saved by killing or hitting the 2 person, then it's good. That is the Bentham idea. And what is Immanuel Kant idea? Suppose you are a doctor and 5 patient has come to you immediately. One has a problem with his heart, one has a problem with his kidney, one has a problem with his liver, one has a problem with his throat. And the requirement is that if you will not change their organs immediately within 1 or 2 hours, they all will die. So you are totally, at that particular time, you are confused what should be done. And suppose at that particular time, one healthy person has come to you for a simple treatment. Now I am giving you one option. That healthy person has got all healthy organs. Will you take the organs from that person and will you transplant the organs of that person to different persons? Will you do that? I don't think so that you will do. But if you are Benthamite, you can do that. What Bentham has said, that end is important, maximum happiness to the maximum people. If you are taking the organs from one person and if you are saving the life of 5 people, it's good. According to the Bentham, it's okay. But Immanuel Kant had said that it is immoral. Your means are not good. Whatever the end you are achieving, it is not important. Your means are not. That is the Immanuel Kant. You have to follow. There are some ethical duties, there are some ethical duties which you have to follow. Duties in the form of the means. If you will not follow those duties, whatever the end you are achieving, it doesn't matter. You are a doctor, you have to follow some professional duties, professional ethics. Those all are your means. If you are not following those ethics, morals, duties, means, and if you are getting the good result, it never matters according to the Immanuel Kant. Means are important. Ethics, duties are important. साधन महत्वपूर्ण है, साध्य नहीं. That is Immanuel Kant. And in administrative processes, we learn the Immanuel Kant philosophies. It is applied on the IS officers. It is applied on the judiciaries as well. When judge gone through with any case, he will never see whatever the result will be. He will never see. He gone through with the what are the facts before him, what are the duties of his which he has to apply. That is important for him. He will never see what will be the result. If I give this decision, what will be the result? He will never see all those things. He will focus on the means, the duties, the fact, the evidence which are before him. Kantian philosophy. So now if you, surprisingly, the same philosophy can be traced out in an ancient past of the India. If you've gone through with we all have heard that particular proposition, कर्म किए जाओ फल की चिंता मत करो. That is one of the remarkable sloka from the Gita, which essence is that sadhya is important, sadhan is important, sadhya is not important. कर्म किए जाओ फल की चिंता मत करो. Do your duties, use your means, use your ethics, don't see the end. Immanuel Kant. Immanuel Kant in a 16th or in a 17th, in mid between the 17th or 18th century, he has given his theory of categorical imperative. But 5,000 or 6,000 years ago, one of the person whose name is Sri Krishna, in mid between the war, he has given the same theorem which we are generally called as an Kantian philosophy. In between the war, Sri Krishna has told us that कर्म किए जाओ फल की चिंता मत करो. Work on your duties. And important, this was not just a theory. The Indian scriptures, the ancient Indian system has also told us that whatever those duties, whatever those means which you have to follow to get the just society, to get the just end. In Manusmriti, it is a very famous sloka wherein the 10 duties are described. Dhrati, Shama, Damo, Astamay, Socham, Indriya, Nigraha, Dhir, Vidya, Satyam, Krodho, Dasakam, Dharma, Lakshanam. These are the 10 duties which every person has to follow, irrespective of any status. He has to say truth, he has to follow the non-violence, he has control over their senses. चोरी नहीं करना है, झूठ नहीं बोलना है, senses पे control रखना है. These are the 10 duties which are described. If you follow those 10 duties, the end will itself come in a better way. You don't have to see the end. Krishna has said, work on the karma. And karmas, what those karmas are? Those karmas are your means, your duties. And what those means or duties are? Dhrati, Vidya, Damo, Astame, Socham, Indriya, Nigra, Dhir, Vidya, Satyam, Krodho, Dasakam, Dharam, Lakshanam. If you follow this pattern, you will get a good result. Immanuel Kant. Immanuel Kant never told about what those duties are. He has just said, follows your duties. He was not able to conceptualize the idea of duties. He has just said that work on the duties, the result will be get sooner or later in a better way. Focus on the means, focus on the duties. But Krishna has said, focus on your duties. And later on, Manusmriti has said that what are those duties which you have to focus? Perfect idea. But we never try to read all those documents. We always do the selective studies of those documents to criticize only those documents. This is it's a type of hypocrisy which is going on. we have to read all those documents, all those literature in an inclusive manner. There is one more example. You all are aware about the social contract theories. The social contract theories, which is a source of the concept of the state. In social contract theory, it is written that when the members of the society, they choose their government or the king, and the king will assure the society that he will take care, he will maintain the law and order, and he will take care of their rights. This is a social contract between the society and the king or the state, and that will ultimately lead to the developed concept of the state. That is a social contract theories. Thomas Hobbes, John Locke, Rousseau, Aristotle, these all are the legal philosophers of the Western philosophers, the Greek philosophers. Those have talked about the contract, social contract, and we generally read about their ideas. The crux of their idea is that the first thing is that they have said, social contract theories idea said, that a king or the head of the state, he must be a philosopher. That is the first. Philosopher in the sense, if he will become a philosopher, if your king will become a philosopher, he will not lead your state in a dictator state. समझदार आदमी होगा, वो कभी भी आपके स्टेट को डिक्टेटर स्टेट की तरफ लेके नहीं जाए. He must be a philosopher. And second, he must not be an absolute one. His power must not be absolute one. Don't give him an absolute power. If you will give them absolute power, he can misuse or abuse those power, and that may lead to a state which may be termed as a dictator state. So these two ideas are the crux of the social contract. These are, you can say, the qualification for a state, for a king, for the head of the state, that he must be a philosopher, and secondly, he must be a king. He must not be an absolute one. His power must be resting. In 15th or 16th AD, these ideas were given. Even Aristotle has given the same idea, that king must be a philosopher. But these theories in a Western parlance come in a just 15th or 16th ADs in a form of theories. Social contract is in theory. Later on, the Western state has followed these theories in a practical way. But 2,000 to 3,000 years back, India had already not only conceptualized these theories of the social contract in such manner, but they have practiced as well. Chanakya, in his famous manuscript, Arthashastra, he has mentioned that what are the qualifications of the prince, what are the qualifications of the king. He has said that king must have the knowledge of law, king must have the knowledge of public administrations, and apart from that, king must have the knowledge of the economics. But apart from that, very important, Kautilya has mentioned around 2,500 around 2,000 years back, he has mentioned in his book that apart from the political knowledge, political science knowledge, apart from the knowledge of economics, apart from the knowledge of the public administration and economics, the king must have a knowledge of the philosophy. 1,500 years back, Chanakya has said the king must have the knowledge of the philosophy, and practically it was followed. I'm giving an example. When Pandavas were during the period of their Vanvasa, when they were roaming around in a thick forest, at that time, what happened? Once they all felt, Kunti and Draupadi, they were felt they were in need of the water. They were very thirsty. So Yudhishthir has give command to their small brothers Nakul and Sahadev to find out the water for them. Both have gone to the nearest place wherein they have found one pond. And the moment when they want to take that water, one Yaksha Rakshasa, he was the owner of that pond. He has appeared and he has told to them, you are not allowed to take water from my pond unless and until you will not give the answer of my questions. But Nakul and Sahdev have avoided him. And the moment they avoided him, they fell down and they got died because of the curse of that water given by Yaksha Rakshasa. Later on, when Nakul and Sahdev didn't come back, Yudhishthir has told to Bhim and Arjuna to go there and to find out what happened. When both of them gone there, the same questions were asked by Yaksha Rakshasa. They were not able to give the answer and they fell down, died. 4 of the brothers were died. Later on, Yudhishthir, he himself went there. And when he has seen that 4 of their brothers were died, he was totally shocked. And that moment of time, and he has said, who has killed my brothers? And that moment of time, Yaksha Rakshasa, he has appeared and that I have killed those all persons. So at that time, Yudhishthir has said, why did you kill my brothers? Because they are taking my waters without my permissions and they are not able to give the answer of my questions. That's why I have killed them. Then Yudhishthir has told to him that whatever your question, just ask me. I will try to give the answer. Look at the circumstances. 4 of the brothers were already died. Her mother and her wife are very thirsty. They are waiting for him. In such situation, look at the calmness of his mind. At that such situation, when Yaksha has asked him 2 or 3 questions. The first question Yaksha has asked, Kima Ashcharyam? इस संसार का सबसे बड़ा आश्चर्य क्या है? And Yudhishthir has replied that everyone knows that he or her will be died. He or she will be died one day. But even after that, everyone is busy in getting the wealth, into getting the, the worldly things. That is the biggest आश्चर्य. सबको पता है सब मरने वाले, लेकिन फिर भी हम लोग इकट्ठा करने में, भागने में, दौड़ने में लगे हुए. ये संसार का सबसे बड़ा आश्चर्य. The second question Yaksha has asked that what is the fastest thing in this world? इस संसार की सबसे तेज चीज क्या है? The Yudhishthir has replied, Mana is the fastest thing in the world. जो मन है वो इस संसार की सबसे तेज चीज है. आज यहाँ कल यहाँ. Yudhishthir, the Yaks was so happy with the answers of the philosophical answers of the Yudhishthir. And he has said, yes, Yudhishthir, you have passed the test of the philosopher king and you will become the king of the Hastinapur. And with that, he has given the life to all those, all rest of the brothers as well. That were the requirement in ancient India, that king, the head of the state, the social contract require in ancient past of the India that king must be a philosopher. Even in those adverse conditions, he has calmly given all those answers. It reflects that yes, king was a philosopher. And not only that, when social contract has said that king must be, his power must not be absolute, it was also reflected in the ancient past of the India. When you gone through the rules of become a king, you will find there are some rules that what are the process a king has to be followed to become a king. In that process, it is written that after Rajyabhisek, after his coronation, the Rajguru will give him an dand. And with that dand, he can regulate the whole public, citizens or the subject. Rajdand. It is known as the Rajdand. With the help of that Rajdand, he can regulate or he can control the citizens. But the moment when he got the Rajdand from his Rajguru, he bent down to take the Asirvad from his Rajguru. At that moment, the Rajguru with a small stick, with a very thin stick, hit on his back and said, Dharma dando asti. Dharma dando asti means कि तुम्हारे ऊपर धर्म का दंड रहेगा, तुम जनता के ऊपर राजदंड लगाओगे, तुम्हारे ऊपर धर्म का दंड है. धर्म दंड means you are also bounded with the duties. You don't have an absolute power. You cannot misuse your rajdand. If you will be guilty, you will also oblige to follow all those duties. You will get the punishment if you will be guilty. It does means what past of the India says, that king is not an absolute. King is not an absolute. King's power is not absolute. We have to read all those documents. Then only we come to know that whatever is dedicated, credited to the contemporary thinkers is already there in the ancient past of the India. And then one more example I want to quote. That you all are aware about the sociological jurisprudence of the Roscoe Pound. While depicting the sociological jurisprudence of the Roscoe Pound, talking about the sociological jurisprudence of Roscoe Pound, famous Judge V.K. Krishna Iyer has said that sociological jurisprudence means that rule of law has to be arise from the rule of life. Means sociological jurisprudence means that whenever the policymakers try to make any law, they must not make that law in a close complex. They have to see whatever is happened in the society, whatever is happened in the life. They have to see what is going in the society, and in accordance with the society, they have to follow those, they have to make all those laws in accordance with the societal interests, in accordance with the rule of life. We have to make the law. This is the sociological jurisprudence. V.K. Krishna here has remarked that rule of law must be emanate from the rule of life. That is a sociological jurisprudence, which you will read. But when you see the concept of a dharma, the dharma says the same thing. The basic meaning of dharma is to sustain. The basic meaning of the dharma is to sustain, to hold. To sustain what? To sustain the society. To hold the ideas of the societies, to hold the aspirations of the societies. That is what dharma has said. The meaning of dharma is that आपको सोसाइटी में जो चीजें हो रही है उसको होल्ड करना पड़ेगा, सोसाइटी में जो चीजें हो रही है उसको सस्टेन करना पड़ेगा. दैट इज द मीनिंग ऑफ द धर्मा. You are duty bound to hold. The lawmakers are duty bound to hold the aspirations of the society. The lawmakers are duty bound to sustain the aspirations to ideas of the society. If dharma will do that, the rule of law will prevail. That is the basic meaning of dharma. Dharma doesn't mean the religion. Dharma means duties. And what are those duties? Duties is to hold the aspirations of the society, to hold the interest of the society, to sustain the ideas of the society. If you will sustain the ideas of the society, if you will hold the ideas of the society, if you will hold the aspirations of the society, it will certainly give you the rule of law. The just society will be there. जो sociological jurisprudence आज बता रहा है वो already था धर्म. We have to analyze. And it is also reflected. It is not like that कि भाई it is only for in case of a written law. In a case of natural law, the same things were there. You know why Yajna and Havan was practiced? Yajna and Havan. if you read the different mantras, the one of the effect of the mantras is to maintain the natural order, the cosmic order. One is the effect of that. If you read the Prithvi Sukta of Rigveda, 51 slokas are there, around 51 slokas are there, which talks about the sustainable use of the natural resources. 51 slokas are dedicated to the sustainable use of the resources. जब आप उन 51 श्लोकों का, उन मंत्रों का उच्चारण करेंगे, तो आप मंत्र आबद्ध होते हो. उसमें बताया गया कि आपको रिसोर्सेज का यूज कैसे करना चाहिए, सस्टेनेबली कैसे यूज करना चाहिए. With the help of those mantra, you become mantra abadha, mantra baddha. Baddha means bound. Mantra means duty to maintain the natural resources. You become a duty bound. जब आप मंत्र करते हो यज्ञ में, जब आप मंत्र बोलते हो, तो you become a duty bound to save the natural order. Natural, and if your natural order will remain maintained, the peace will be there, and the peace will be there. The society will feel the peace, and the society will feel the peace. It means the social order will be there. If social order will be there, the legal order will be. So we can say this sociological jurisprudence, that rule of law, must be immense from the rule of life. It was there in a dharma. It was in there the meaning of the dharma. It was there in the meaning of the mantra. So what we have to do, ultimately what we have to do, if we will try to find out, firstly, we will have to compare the contemporary jurisprudence with the ancient jurisprudence. And when you will able to compare both the jurisprudence, then you will feel that there might be some more methodology, some more procedures, some more alternative options in our ancient legal system, which can help to not only resolve the conflict, but to avoid the conflict as well. It is a task before us that has to be followed. We have to follow, and we have to do this particular thing. And you know, the good thing is that we, in an initial stage, as I have already said, that we are seekers, we are not believers. Use this natural habit of seeking, and with the help of those seeking, we can do anything. Lastly, I want to just quote one of the famous traveler, Louis Rigaud. In 1876, he has written one book, India and its Native Princes, wherein he has remarked about the tendency of the Indian, with the habit of the Indian, that how liberal we are to opt the things. He has remarked that our labors are in vain. Our labors are in vain means you want to convert the people. Our labors are in vain. You can never convert a man who has sufficient conviction in his own religion to listen. Our religion has given us conviction that you must listen to other people's. You can never convert a man who has sufficient conviction in his own religion to listen without moving a muscle to all the attacks you can make against it. आप कितने भी अटैक उस एक भारतीय के ऊपर कीजिए, वो फिर भी आपको सुनेगा, because he is a tendency of seeking. Then use those tendencies. Please use that habit of the seeking, and with the help of that habit of the seeking, just try to dwell out, to find out, to explore our ancient past and our literature. Then you can come out with a proper and inclusive jurisprudence. Thank you very much.
Thank you so much, sir. Sir, should we open for questions?
Yes.
Okay. So, certain questions have come to me. The first is that Sir, if you're saying that we are the Grundnorm of all legal philosophies, then why is our constitution an amalgamation of various constitutions of the world?
Can you please repeat the last statement?
So they're saying that if we are saying that the Grundnorm, we are the Grundnorm of all philosophies, so why is our constitution the amalgamation of all legal philosophies?
First of all, we have to understand that this particular, when I say that Grundnorm of all legal philosophy, it does mean that the past of the Indian, the literatures, the Indian literatures, the Vedas, the Upanishads, the Puranas, I consider them as a Grundnorm of all legal philosophy. I'm not saying that those all are the Grundnorm of constitution. Right now, we have to accept this fact that constitution is a Grundnorm of our legal system. What is my point is that whatever the legal philosophies are there in a legal parlance, in a jurisprudence, you can find out those all legal philosophy in ancient past, in ancient Indian literature. That's why I have remarked that ancient literatures are the Grundnorm of legal philosophy. I'm not saying that ancient legal system is a Grundnorm of constitution. I'm not saying that particular. Constitution is a Grundnorm for our contemporary legal system. These are the two different things. Okay, the constitution is there for to lead our social life, to lead our political life. If you want to find out what should be our social life, then you have to find the traces in a constitution. If you want to find out what should be our state, what should be the political system, you have to see those all fact in a constitution. So for our social and political life, the constitution is Grundnorm. But for all legal philosophies of the world, the Grundnorm may be an Indian past of the Indian literature.
Yes, very rightly said, sir. The next question is that while the concept of oneness may be intellectually appealing, can this philosophy of oneness help in establishing a universal religion?
Okay. Universal village.
Religion, universal.
Okay,
religion.
Universal religion. I'm telling you, the one fact is, personally, I never feel that there may be a concept of a universal religion. You all might consider me a little bit biased, but I'm telling you, when I have done a contemporary studies of different religion, I have find one fact that Hinduism has a great thing with that Hinduism always said that you become a god. You become a god. That is a oneness, Advaita. You become a god. But I never find the same fact in other religion. The other religion always says that you are subject to the god. You will never become a god. The god is the foremost and the uppermost thing. Those religions, I'm not saying that those religions are bad. I'm not saying this particular thing. I'm just comparing those the different religions. Hinduism has given you the opportunity to get the best. It says that you become a god. Aham Brahmasmi, Mahi Brahma. I am a god. But no other religions has said the same thing to you. They never allow you to become a god. They never allow you to become a god. So if you do the comparative study, it is from that particular fact, I can't say that there must be a possibility of universal religion. It is a very tough task. It might be possible if you agree with the tenets of Hinduism. Then it is possible. Otherwise, it is not possible. If we will be stuck with our religious fact that yes, the God is the supreme, no one is better than God, or no one can equate with the God, then the concept of universal religion is not possible.
Okay. So the next question that we have is that do you think that whether we are following the legal philosophy as enunciated by Advait Vedanta, and also how Vedas and Manusmritis is being adopted in our legal philosophy?
Okay. Susmita, can you please repeat that question?
Yes, sir. It is that do you think that whether we are following the legal philosophy as enunciated by Advait Vedanta, the present system that we have, is it based on Advait Vedanta? Also, how is Vedas Manusmritis being adopted in our legal philosophy?
Okay. I just want to give you one example. It is there. Even in our constitutions, we have followed those all philosophies. I'm just giving you one example. When you go through with we all have to read the Constituent Assembly debates in when the Article 25 was in the process. At that particular point, many assembly member has suggested that we must use the word right to worship. In spite of freedom of religion and in spite of freedom of concise and all this thing, in addition to those all things, we have also used the right to worship. So this was suggested, but Kanhaiyalal Munshi, one of the most intellectual person in our Constituent Assembly, he has said that right to worship is a Western concept. When you say that right to worship, it requires that you can do for that worship, you need a particular place, either a church, either mosque, or either a temple. But in an Indian context, the Indian philosophies never restricted over to any particular place for worship. अद्वैता कभी ऐसा तो नहीं बोलता है कि आपको मंदिर ही चाहिए, वहां पे जाके आप अद्वैत फिलॉसफीज को पढ़ सकते हो, कर सकते हो. नो, यू कैन, आप एक पेड़ को भी अपने जैसा मान सकते हो, उसकी पूजा कर सकते हो. आप पत्थर को भी अपने जैसा मान सकते हो, उसकी पूजा कर सकते हो. आप नदी को भी अपने जैसा मान सकते हो, उसकी पूजा कर सकते हो. दैट इज द इंडियन फिलॉसफी. अगर आपने राइट टू वर्शिप डाल दिया, तो भारत में जो गणेश महोत्सव बाहर होता है, शिवाजी महोत्सव बाहर होता है, वो कैसे पॉसिबल होगा? क्योंकि राइट टू वर्शिप तो रिक्वायर्ड ओनली अ पर्टिकुलर प्लेस. भारत तो नदी में भी भगवान देखता है, पत्थर में भी भगवान देखता है, पेड़ में भी भगवान देखता है. हमारे यहाँ गांव में एंट्री करती कुल देवता है, ग्राम देवता है, ग्राम देवी है, कुल देवी है. उसके लिए कोई पर्टिकुलर स्पेस, जगह की जरूरत हमें नहीं है कि सिर्फ मंदिर में ही पॉसिबल है या सिर्फ मॉस्क में ही पॉसिबल है. नहीं, कहीं भी, सब जगह हमने अपने आप को, हम किसी को किसी से अलग मानते ही नहीं है. अद्वैत फिलॉसफी, on the base of that philosophy, we never included the right to worship. के.एम. मुंशी ने यही बोला कि अगर आपने के.एम. मुंशी and Ambedkar has said, both have said that you can't imagine India without religion. इंडिया को रिलीजन के बिना समझा ही नहीं जा सकता. और the religion is everywhere at every point of time. And if you are inserting the word right to worship, it does means that you are restricting the Indian concept of Advaita philosophy. That's why they never use the word right to worship in Article 25. There is a freedom of concise. Whatever you are concise, accepting, do that thing. Yes.
Sir, we have one more question that if we look at today's society, then even today the ratio of 100 Kauravas, which are categorized as the bad people, is balanced by 5 Pandavas, who are the good people. So do you think our state laws are capable to protect the good people's well-being across our society?
Yes, exactly. Our laws are they are really, especially if you see the Indian Constitution, the Bharatiya Constitution, it is strong enough to protect the minority as well. Minority in the sense, I'm not talking about any religious or cultural or linguistic minority. I'm saying if there are lesser number of good people, even they are protected by our Indian constitutions. I'm giving you one example. Suppose, if you see the preamble of the Indian Constitution, there are 3 words: we the people, parliamentary democracy, and republic. There are the 3 words. Suppose we the people, मान लीजिए जितने भी we the people वो सारे खराब लोग हैं, मान के चलिए, they are bad people, बहुत सारे हैं, और उन्होंने एक खराब गवर्नमेंट बना दी पार्लियामेंट्री डेमोक्रेसी के थ्रू. हो सकता है वो खराब गवर्नमेंट आपके लिए कुछ गलत करे, वो एक लॉ बनाएगी, और वो लॉ जो कुछ अच्छे लोग हैं उनके लिए अच्छा नहीं है, लेकिन बहुत सारे जो खराब लोग हैं उनके लिए अच्छा है. मान लीजिए ऐसा हो गया. इट इज पॉसिबल टू रेस्ट्रिक्ट दिस थिंग. द रिपब्लिक वर्ड इज देयर. The word republic is there. Unless and until the parliament will not get the assent of the republic, that is the head of the state, the law will not be passed. So to avoid the possibilities of the bad laws, to restrict the bad laws, the republic word is there in Constituent Assembly. We the people may be bad, parliamentary democracy may be bad, and with the help of, with the amalgamations of both of these entities, a bad law may come, but this bad law will not come into the effect unless and until the president, the republic, will not get the assent. That's why the word republic is there. And there are a lot of restrictions in our Constituent Assembly. The similar restrictions are there, which pave the way for the good laws and to save the good people. Yes.
Sir, one more question. Can you differentiate between Indian legal philosophy and Hindu legal philosophy?
Okay. First of all, I am little bit earlier when I started my journey about the jurisprudence. Earlier, I was very much fascinated with this word Indo-prudence. But later on, I must confess this thing, that now I am on that particular point. I reach on that particular point where I can say there is no difference between Indo-prudence and Hindu-prudence. The major work of the Indo-prudence, and when I say Hindu-prudence, it includes Hinduism, Jainism, Buddhism, all 3 religions. Hinduism, Buddhism, and Jainism. If you gone through with these all religious scriptures, or these have a code of conducts. The best thing with the Hindu prudence, which includes Hinduism, religion, and Jainism and Buddhism, they don't have a code. They have a code of conduct. They have a code of conduct. They never say that this is a law. They say these are the duties. There is a difference. There is a difference between West and the East. West always talks about the code, excessive positivism, law must be there. But the East always says that there are some code of conducts. If you follow those code of conducts, you will get the justice. There is no need of law as well. So I must say, there is no basically difference between Indian legal jurisprudence and Hindu jurisprudence. And Hindu jurisprudence includes Hinduism, Jainism, Buddhism as well, and subsects of these all religions as well. Yes.
But sir, should the aspect of religion?
And I'm telling you, there is no dispute over this particular word. There must not be no dispute. Rama Joyce has used this word. Justice Rama Joyce has used this word, Hindu prudence. Lot of legal philosophers, lot of judges have used this word, Hindu prudence. So there is no dispute over this particular word, or there must not be dispute on that particular word. The word Hindu is not reflecting any religion. It talks about amalgamations of code of conducts, talks about the code of conducts, about the duties, about the ideas only.
So the concept of Bharatprudence is free from religion.
Yes, it is free from religion. It includes Jainism, Buddhism, and Hinduism.
But sir, when we talk about Jainism,
Bharatiya religion, I am talking about the Bharatiya religions.
Okay.
Specifically Bharatiya religions. Because no, look, the other religions, I'm not saying that we must not respect we should respect other religions, but the time when they came into the India after 10th AD, that was not a period of literature development. That was not period of reading and writing. That was the only period of aggressions, formations of states, the formations of empires. That was a period of just an empire. And if you are following the Western ideology, अगर आप Western ideology follow करते, that was in dark age. That was in dark age.
Sikhism should also be a part of this Indo-Prudence, right?
Just criticism.
So Sikhism.
Yes, it is also. It is. I have already said that the subset of those all religions. Subset of all those religions. Sikhism is a subset of Hinduism. If you've gone through with the family laws, which was drafted by Dr. Ambedkar, it is clearly written. The definition of Hinduism is there. It includes Buddhism, Jainism, Sikhism, all are there.
Thank you, sir. Those were the only questions that we had. Thank you, sir, for deliberating on this illuminating topic that you chose today. Rightly said, sir. Advait is the harmonizing element which is upholding the equity and equality, and it is also very necessary for our society today when we are combating with sectarianism. Also, sir, Bharatiya jurisprudence being the groundnorm of all philosophies, like you enumerated, in respect to philosophies of Kant, Rawls, and social contract, it was very brilliant, sir. Thank you for the enthralling lecture that you delivered. I would now like to request Professor Tanaya Kamlakar to propose a formal vote of thanks. Thank you so much, sir.
Thank you.
Thank you, Professor Susmita. It is my privilege to propose a vote of thanks for such an enlightening session. I, Professor Tanaya Kamlakar, on behalf of KLE College of Law, Navi Mumbai, would like to extend a hearty vote of thanks to our honorable guest speaker, Professor Vikramaditya Rathore, sir, who took out valuable time from his busy schedule to share his knowledge with us today. Sir critically analyzed the aspect of whether our legal system has a Bharatiya essence in order to achieve the social independence. Sir drew a beautiful nexus between Article 25 and the Advaita philosophy. Thank you so much, sir, for this wonderful session. It is always a privilege to hear from you. I would also like to thank the members of KLE management for their blessings and guidance. Dr. Prabhakar Kore, sir, Chairman, KLE Society, Belagavi. Dr. J.M. Mallikarjunaya, sir, Principal of KLE Law College, Bangalore, and Director of KLE Law Academy, Belagavi. I also wish to express my gratitude to our Principal, Professor Dinkar Gitte, sir, for providing encouragement and support in organizing this event. I extend a big vote of thanks to our faculty members for their constant support. Last but not the least, I would like to thank the participants and the whole organizing team. Thank you so much, everyone. Thank you so much, sir.
Thank you. Thank you, Professor Tanya. Thank you, Susmita. Thank you, Professor Susmita. And thank you very much to Principal, sir, and all other faculties who has given me an opportunity to interact with you on such an interesting topic. Thank you very much.
Thank you so much.